turn to the third case on this morning's docket. Isherwood's doing triple duty. This is case number 106865, State of Kansas v. James F. Williams.
Good morning. Adam Stolte with the Appellate Defender Office, appealing for the appellant, Mr. Williams. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. I was assigned this case about a month or so ago, and when I initially went through this case, I thought it was a simple kind of sufficiency of the evidence argument. And as I started going through it more and more, and in my preparations over the last week, I realized that there's a lot of underlying issues that weren't necessarily addressed properly in our brief. The first issue being which is now glaring, to me at least, a Prindy problem that there is in this, and a DECOM issue that is I just can't get out of my head on this case, and for those reasons I would inform the court that I'm going to file a motion to file a supplemental brief this afternoon so I can more adequately address those issues. But in speaking to how this brief was argued,
what was the second issue, counsel?
US v. DECOM. It's spelled DECAMPS, but it's the lovely French, so it's DECOM. So what was argued at the sentencing hearing in this case was that defense counsel was really arguing that the evidence surrounding the event in Ohio, which is the prior conviction that we're dealing with on this case, failed to demonstrate an intent to permanently deprive to support the theft element of burglary. And it really kind of you have to kind of jump back on this one again, because in Ohio, there's the 1996 conviction. In Ohio, burglary statute at the time read that the essential elements were that the defendant trespassed in an occupied structure with the purpose to commit therein any criminal offense. That kind of speaks to one of the issues on DECOM, that the statute is more broad than what we have. Our statute for aggravated burglary, which is what this was considered, was that without authority entering or remaining into any building in which there's a human being with the intent to commit a felony, theft, or sexually motivated crime therein. And what they did at the district court level is try to pin this down to the theft element under our aggravated burglary to get this to be a person felony. So then after you see that, you have to look back at what they found below in Ohio. In Ohio's theft statute, states that it's 2913.02, this is back in 1996, said that no person with a purpose to deprive the owner of property or services shall, and it kind of goes on, but it doesn't say permanently deprive. And so that's what was argued below. And our statute for theft requires a permanent action of depriving the victim on that case. And so the way this was argued at the district court level and also in our brief here was that it is basically an insufficient evidence to prove that the defendant in this case permanently deprived. The district court here used an indictment, a complaint, and one of their documents eluding me here at this point. But in doing that, in making its analysis in this case, the district court violated really a Prindy by making a judgment on the facts. The district court said, in my own opinion, I believe that this is what actually happened. And then what actually happened was, once the district court started doing that, they started violating a Prindy. They started making a determination of what happened below.
In the Ohio prosecution, was it a guilty plea or a trial?
It's unclear from the record. But
the factual determination of what occurred had happened either way, hadn't it?
I don't understand.
Well, I mean, the only fact that the judge here was considering was the fact of the conviction itself, not the facts that underlay the crime, was he?
No, he went straight to the facts of beyond the fact of a conviction, and he did go straight to the facts of what happened below. It's on I think it's in volume 2. It starts around page 2, I think, is when the state starts arguing that they start comparing the Ohio statute to the Kansas statute, and they say that, and they immediately jump in and say, if you look at the facts of what happened, based on the complaint, they say what we think happened was a theft. And that kind of brings back to the DECOM, is why I'm going to file a motion for supplemental briefing. It's because the DECOM specifically says that that is not allowed by district courts. They're not allowed to do that. They're not allowed to go and have this hypothetical situation of what occurred.
So in your understanding of now what's required with Apprende, or even what the trial court was required, how the trial court took its approach in determining whether or not the statutes are the same or similar enough to find that it's the same as our aggravated burglary, what at a hearing before a jury, or what the trial court was supposed to do is what? Because ultimately, I think, as Justice Byers pointing out, isn't this a legal determination that the court must make, that the statutes are similar in order to find that it's a person felony?
Right, and that's when you first look at this case, you think we're just arguing about 3 months on a guy who's got a life sentence. But
I understand the significance between a person and a non-person. It's hugely significant.
Right.
But what I'm getting at is the determination that the statutes are the same, so the court can find, yes, that's a person felony.
Right, and that's kind of where...
I don't understand why that isn't a legal determination, that is not a finding facts that a jury would have to do. And first of all, that first prong, but isn't that what the task is?
That's what the task is. The task is to make a legal determination, and that's what the DECOM says. It talks about 2 other cases, Taylor and Shepard. And in those cases, they talk about divisible and indivisible statutes. And depending on whether or not you have a divisible or indivisible statute, use a couple different, 2 different methods of determining whether or not the prior convictions, how they can be classified. It basically comes down to this. It basically comes down to, you're not allowed to re-litigate the facts of the prior conviction. You're only allowed to make categorical decisions. And so if a statute's divisible, which is a statute that has alternative elements like our burglary statute here, you can commit a burglary in a dwelling, a car, a boat, or airplane. So that makes that divisible to that element. And so what you do there is you use the modified categorical approach, which is talked about in the Shepard case. You can look at the indictment to determine which alternate element was used to get that conviction for burglary. In this case, we can look at the alternate elements, or we can look at the indictment to determine that was a dwelling or a structure and for these purposes here. But you can only make an elements comparison. You can't compare the facts of what actually happened. And in DECOM, the Ninth Circuit reversed the Ninth Circuit, because the Ninth Circuit was going through and making these hypothetical approaches as to what actually happened. And again, I think I can word it better in a supplemental brief. But
so basically,
as
I understand it, basically what you're saying, and I think that was your point, is that the Ohio statute requires any criminal offense,
right?
And for aggravated burglary in Kansas, it's limited, or not limited, but it includes a felony, theft, or sexual battery therein. And any criminal offense can encompass anything. You don't necessarily go to the facts, and therefore it's broader than what we are. So it's not comparable.
Exactly. That's the analysis. And DECOM relied on, I think that was the Taylor case to do that. Because
if we
it's broader,
disagree with you, is the everything over? I mean, if we say that comparable means comparable, not identical, and that a criminal offense is comparable to any felony or theft and aggravated battery, does that resolve it? Regardless of what the district court may have done on fact-finding or whatever, if those are comparable statutes, isn't the issue over?
I guess we have one more court. But
I'm sorry,
I don't think it can be resolved in this case because it's broader. It's broader and actually on two
No,
different
that
ways.
wasn't my question. My question is, if we decide they're comparable, do we need to look at anything else? Doesn't
I
that
think-
resolve the issue?
No, I think you do need to look at. I think you do need to look at DECOM on this case, and especially in its analysis of the Ninth Circuit's decision, because that's essentially what happened. What happened here in the district court level is that the district court level said, "Well, it's close. So let's look at the underlying facts to determine what actually happened here." And that's what the DECOM case says, is that you can't do that. You're not allowed to relitigate these facts. And it cited specifically to Apprendi in the defendant's Sixth Amendment right to jury trial and have the jury determine the facts in the case. But it also cited a more practical approach too, which is where looking at these documents, it's to determine what actually happened is not reliable because the defendant in this case may not have had a dog in a race, so to speak, to argue whether or not a theft occurred.
I think
Because
what
it
my
was
colleague
irrelevant.
is, excuse me, go ahead. I think what my colleague was trying to suggest is that district court may have been right for the wrong reason.
Okay, I don't think they were right. I think they were wrong to make this.
I think
a
the
personal.
rationale was wrong.
No, I think their ultimate decision finding this to be a person felony was wrong. And actually, the more strictly that you view DECOM, it really points to eliminating use of this prior conviction altogether. And that's kind of another reason for the supplemental briefing. It's because where DECOM says that where it's overbroad and it includes a broader swath of possible offenses than you're trying to compare it to, it can't be used. And that's, period. It ends the sentence right there. It cannot be used. As I was saying before, that one of the practical approaches for this is because Mr. Williams in this prior conviction, it didn't matter what the criminal offense was. It didn't matter. He didn't have to argue theft. He didn't have to argue anything. Any criminal offense worked. So whether or not he was arguing whether a theft occurred or whether, I think below he argued that he was going to staple stuff on the wall, so some kind of criminal destruction of property or something. It doesn't matter, and that's why DECOM is important here, is because it doesn't matter that he was charged with theft. It doesn't matter that he was charged with anything, and so that's why we can't use this prior conviction.
So you, I'm understanding, you basically argue this is a legal issue. We don't look to the facts, but that when we look at this just kind of on its face, that because the Ohio statute cuts a much broader swath than the Kansas statute, as you said, that they simply aren't comparable.
Right. Right. Because it's so broad. I mean, when he was in Ohio getting this conviction here, he could have argued. I mean, he couldn't have known that he was going to be here in Kansas and facing this or with this charge here. So he wouldn't have, when he was in Ohio, he wouldn't have necessarily had to argue whether or not what the underlying offense was for that, for the burglaries, the Ohio burglary statute. So arguing whether or not a theft occurred now is where the violation of Apprendi occurs, because we're now litigating facts not actually that shouldn't be relitigated, and it's clear from the comment that's the route we're supposed to take.
Just so I'm clear, you're saying as a matter of law, given the way the Ohio statute is worded, we simply cannot perform any kind of a comparative analysis. We're just done. And
Right.
so we can't look at any other statutes in Kansas, criminal statutes, to see if they would be comparable. It's just a pointless exercise.
As my understanding of DECOM has developed over this last month, really, I mean, that's really what DECOM says. Where it cuts a broader swath, it can't be used, because pinpointing where they stopped arguing, what they argued, is really impossible. And really under Taylor and Shepard, it really becomes irrelevant under the DECOM analysis.
And the cases you've been discussing with us today is the first time we've heard about these from your side. Is that correct?
Yes, Your Honor. That's the reason I'll be filing a supplemental brief or requesting a motion to.
And I'm kind of curious how is opposing counsel to respond to the cases you've discussed with us today, other than his hearing about them?
I think at least Apprendi is an issue that's widely known, and I think the COM is at least in defense circles, is becoming a pretty widely known case as well.
Just so I'm clear, was there any indication from you before you spoke today that we were going to be receiving any kind of supplemental authority from you, whether it was a 609 letter or supplemental briefing?
No, Your Honor. But when I had the aha moment after the 609 timeline had passed.
All right. Any further questions? Thank you, counsel.
Thank you, Your Honor. Thank you.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. And this is the part of the day in an argument where I either really clarify things or really embarrass myself.
Well, help start clarifying.
Okay.
In 2001, this exact same conviction was utilized in McPherson County, as I understand it, and was assessed or was as a non-person felony.
That's correct.
And now you're turning around 10 years later and saying it is a person felony. And how does that work?
Well, I don't know that there was I don't think the record indicates that there was a hearing in McPherson County. I think what you're suggesting is possibly some kind of res judicata or law of the case. And
Not necessarily that, but why can't a defendant rely on a prior understanding and a prior utilization in a sentencing that impacted him, and there's been no change in the statute as far as I understand in terms of making it a non-person to a person? It's the same statute applies. Why can't he rely on that when trying to determine what is going to be the impact of my plea?
Because I don't think that there had been a hearing on that on the merits of it. I don't think that it had been determined, and I could be wrong. I'm not privy to the ongoings of McPherson County. I don't believe there was a hearing on the merits is the short answer.
Okay.
But with my second attempt to clarify, I guess I'm going to start at the beginning. I always find that a great place to start. And it's my understanding that there may have been a lot of confusion at the district court level because in my estimation, what's happened here is the defendant's counsel, the only argument was whether it was going to be a non-person or a person. Defendant's counsel indicated, well, you can't show an intent to permanently deprive, therefore it's a non-person. The intent to permanently deprive has no bearing whatsoever on whether it's a non-person or a person. The intent to permanently deprive only has bearing on whether there was a crime, which is something that he is not allowed to dispute at the time of sentencing. That is my understanding, and again, some of this is coming for the first time right here or right over there, but I thought De La Cruz indicated that you are not allowed to attack your prior convictions at sentencing. You can tell me it wasn't yours, and we can prove it's yours, but you can't just attack, well, you know what, there's an element of the crime that I don't think happened, so you can't count that. The defendant is not entitled to do that. The only issue was whether it was a person or a non-person. Whether there was an intent to permanently deprive doesn't change that. In Kansas, burglary is a person if it happens in a dwelling, or it's an aggravated burglary if someone's present, whether it's a dwelling or not. That was the only issue that should have been before the district court. Not claiming to be psychic, but having an understanding of what is going on in the law, I'm somewhat prepared to speak to, I guess, DeCamps, or however it's pronounced. It was my understanding that if it was a divisible statute, that you could look at relevant, a limited source of relevant documents to determine whether an element was present. And I think in this case, even if you look at original opposing counsel's brief, they talk about an indictment, an Ohio indictment that indicated that it happened in an occupied structure. So if that's the only issue that makes it a person or a non-person, then we can look to the limited category of documents, one of them being the indictment, clearly indicates it was occupied making it a person felony. But again, it would seem to be a little late at the podium to request a supplemental brief that changes your issue completely. As we indicated in our brief, the only issue that the defendant continued from below into his brief was that there was no intent to permanently deprive. That doesn't get you anywhere. That's a non-starter. It gets you nowhere. It doesn't have any impact on whether it's a person or non-person, and it's not something that you can complain about at the district court level. The only thing you can complain about your priors, two things, not mine, one, not counseled. This isn't that. So we would ask the court to address the issue that was briefed. And that issue does not find any relief for the defendant. And I think I've supplied, in the event that this court continues on and addresses the issue from the podium for the first time, I think I have accurately indicated another way that the district court could be correct, obviously not for the reason because that wasn't challenged below. But I do think you can look at a limited category of information, and I think the Ohio indictment would fall within under DeCamp, whatever. Unless the court has any questions about either the issues briefed or the issues from the podium.
Well, let me just clarify here. So if in Ohio, the defendant went into the structure with the intent of littering, that would satisfy the aggravated burglary statute in Ohio.
Well, now
is that a similar type? I mean, we're just looking. So what you're saying is that doesn't matter.
Well, I think
that doesn't matter because that's a felony in Ohio under their, call it whatever it is, aggravated burglary statute. In Kansas, that is not an aggravated burglary.
Well, I think it was Justice Johnson. Two things, I guess. One, I think it was
is that comparable? I don't know if it's
comparable. That's where I was.
You think that's comparable? Going in and I'm going to litter. I'm going to do some criminal damage, which would make it a criminal damage case in Kansas, but it wouldn't make it an aggravated burglary. In Kansas, and is that comparable?
Well, I don't think that the comments from Your Honor are possibly comparable, but I think that if you look in the indictment, and this issue is being brought for the first time for the podium, and I cannot recall. I remember from the briefs that the judge had indicated there was something about the theft of a stapler and something else.
And knife.
Yeah, and I think that was. I don't know where he got the information, which compounds the issue, because you can only look to certain. I don't know where he got it, and I don't think that the Ohio case was a plea. I could be wrong. So I don't know where that information came from. So I don't know that, again, the issue raised below was simply whether it was a person or a non-person. And the claim of whether it was an intent to permanently deprive gets you nowhere under that. And I think I've done the best I can from the podium of for the first time, advancing the argument as to how you can, if you choose to allow the defendant to make a new argument from the podium about why it shouldn't be included, and now defendants get to attack every conviction at the time of sentencing on any element whatsoever, then I think I've advanced the argument as far as I can for the first time.
Any further questions of counsel? Thank you.
Thank you.
I think I can start by apologizing for kind of dropping this on the state's lap here this morning. But to address kind of the argument that was raised in the district court, I think the argument that was raised in the district court was whether or not it was permanently deprived, which is the first step in determining whether or not it can be a theft. If it can't be a theft, it can't be an aggravated burglary. And so I think that's the argument that that was made at the district court. I think that you can find in our favor based on that argument as well.
That's a factual argument.
It's a factual argument, which is, again...
So what about Dela Cruz?
I am unfamiliar with Dela Cruz at this point, Your Honor.
Okay.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.